And hear you, Your Honor.
Okay, thank you. I can hear you loud and clear now. Sounds like we're ready to go then, Mr. Brockman. You may ask your next question.
Thank you, Your Honor. Good morning, Professor Quinn. Thank you for being with us here again this morning. Just to briefly recap what we discussed at the end of the day yesterday, you have advanced degrees in political science, is that correct?
Yes.
And you also conduct research and publish papers in the fields of political methodology and empirical and applied statistics, is that correct?
Yes, that is.
And also in the fields of empirical legal studies?
Yes.
And you also serve on journals in those areas of scholarly research?
Yes.
And you have previously been an expert witness, is that correct?
Yes.
And you have been an expert witness in cases dealing with voting rights, is that correct?
Yes, that's correct.
And Professor Quinn, at the end of the day yesterday, I believe we were discussing the fact that you had been an expert in a prior case involving HB 589, the Curry litigation. Do you recall that testimony?
Yes, vague, the exact details, but yes, I was an expert in that case.
And on what subjects did you offer expert opinion in the Curry case?
In the Curry case, the question was, to what extent do registered North Carolina voters lack qualifying ID under HB 589, and also the extent to which there was or was not a racial disparity in ID possession.
Thank you. Are you being compensated for your work in this case?
I am, yes.
Are your opinions or conclusions in this case contingent in any way on that compensation?
No.
Your Honors, at this time, based on the testimony yesterday and which I briefly recapped this morning, plaintiffs would move to qualify Professor Quinn as an expert in the fields of political science, including political methodology and applied statistics, based on his training, education, and knowledge under North Carolina Rule of Evidence 702.
Is there any objection from any defendant?
This is Pete Patterson. No objection from the legislative defendants.
No objection from the state defendants.
The witness is so received. Thank you. You may proceed.
Professor Quinn, have you submitted any expert reports in this case?
I have, yes.
How many?
3.
And in those reports, did you review a law known to you as SB 824?
Yes.
At a high level, could you please tell the court, what is your understanding of SB 824?
SB 824 is a North Carolina law that implements a photo voter ID requirement.
And with your Honor's permission, I'd like to publish to the court JX 38, which is a copy of the report Professor Quinn submitted at the preliminary injunction stage of this case.
All right.
Professor Quinn, I'm showing you what has been marked as Joint Exhibit 38. Do you recognize this document?
Yes, I do. It's my report from the PI stage.
And can you please explain the issue that you analyzed in this report?
So in this report, the question again was, the question again was, to what extent do North Carolina voters lack qualifying forms of ID under SB 824? And to what extent was there not a racial disparity in ID possession?
And how did you analyze that issue in your preliminary injunction report?
So at the PI stage, I didn't have access to the ID databases that were later produced. And so at this stage, what I needed to do was to take whatever data were available and try to formulate a best guess as to what the state of the world was at that particular point in time. And so what I did was I relied on the evidence from my Curry report, along with some additional information about the extent to which various demographics in the state had changed or not changed during that period between the Curry litigation and the PI stage of this litigation.
And what conclusions, if any, did you reach in your preliminary injunction report?
At a very high level of generality, the conclusion was that the racial disparity that I found in the Curry litigation, there was no reason to think that a similar type of racial disparity was not present at the time of the PI stage.
And just for the record, what was the nature of the racial disparity that you found in your Curry report and which you concluded was unlikely to have changed in your PI report?
In the Curry report, I found that African-American voters were a little over twice as likely as white voters to lack qualifying ID.
Thank you. Your Honors, with your permission, I'd like to now publish Joint Exhibit 5, which is Professor Quinn's report from December of 2020 in this case.
If there's an exhibit that has been received as a joint exhibit, you need not ask my permission to publish it. You can simply tell us which exhibit you're publishing.
I appreciate that, Your Honor. With respect to the expert reports, the parties had stipulated that these would be received once the expert testified, so I believe these have not yet been admitted.
Well, if there is a report that is agreed upon to be received, you need not ask my permission to publish it.
Thank you,
Any
Your Honor.
exhibit that you all have agreed can be received. You don't have to ask my permission to publish it. You can simply do it. But it is good that you name it by number and by a brief description for the record before you publish it. But you need not ask my permission to do that.
Thank you very much. Professor Quinn, I'm now showing you Joint Exhibit 5. Do you recognize this document?
I do. It's my December 2020 report.
And can you please explain to the court the issue that you analyzed in this report?
Again, the question here was to examine the extent to which North Carolina voters lacked qualifying ID under SB 824, and also the extent to which there was or was not a racial disparity in ID possession.
And Professor Quinn, when you use the phrase qualifying ID, can you explain to the court what you mean by that?
Yes, I can. So by qualifying ID, I mean ID that would be acceptable for the purposes of voting under SB 824.
And in your December report, JX5, did you update the method of analysis that you used in your preliminary injunction report?
I did, yes.
Okay, I'd like to talk to you about that in a few minutes, but before we get there, at a high level, what did you conclude in your December report?
So in the December report, I found that African-American voters were about 39% more likely than white voters to lack qualifying ID. And that disparity was even larger if we look at recent voters. So among those who voted in 2016 and 2018, Black voters were about twice as likely to lack qualifying ID than white voters.
Thank you. I'd now like to publish to the court Joint Exhibit 697, which is Professor Quinn's rebuttal report in this case. And Professor Quinn, do you recognize this document, Joint Exhibit 697?
I do.
And what is it?
It's my rebuttal report from this litigation, January of 2021.
And could you please explain briefly the issues that you analyzed in your rebuttal report?
So I was asked to examine some of the empirical claims that were made by opposing experts, Drs. Hood and Callanan, and to assess the extent to which those empirical claims were supported by sound empirical principles.
And what conclusions, if any, did you reach in your rebuttal report, Professor Quinn?
The conclusions I reached were that most of the empirical claims that I examined were not supported.
Now, with respect to all three of the reports we just looked at, did you draft these?
I did, yes.
Do they completely and accurately reflect your opinions in this case?
They do, yes.
Your Honors, pursuant to the party's stipulation, plaintiffs would move to admit Professor Quinn's reports JX5, JX38, and JX697 into evidence and as Professor Quinn's testimony in this case.
Exhibits JX5, JX38, and JX697 are received. Thank you.
Professor Quinn, in addition to the electronic copies of your reports that we just looked at, do you have your reports in hard copy with you today for ease of your reference?
I do, yes.
And just for the record, have you made any notes on those copies of your reports?
I have not, no.
And if at any point during your testimony today you refer to one of those printed copies, will you let us know so that we can please get all on the same page and share that page on the screen for the court as well?
I will certainly try to, yes.
Thank you. Now, you testified that you testified earlier that you analyzed in your reports SB 824. To your understanding, is that the first voter photo ID law to be enacted in North Carolina?
No, it's not.
To your knowledge, what photo voter ID law was enacted prior to SB 824?
HB 589 was enacted prior to SB 824.
And that's the photo ID law that you examined in the Curry case, is that correct?
That is correct, yes.
Do you have an understanding sitting here today of HB 589's requirements?
Yes.
And what is that?
So HB 589 enumerated a list of photo IDs that were acceptable for voting at the time. And is the question of which sorts of IDs were allowed under HB 589, or just the general question of what it did?
Just the general question is fine
Okay.
for now.
Okay,
And had you completed your answer, Professor Quinn?
I had, yes.
Do you know one way or the other whether HB 589 is still in effect today?
It's not in effect today.
And why not?
The Fourth Circuit struck it down.
And is it your understanding that SB 824 was enacted before or after the Fourth Circuit decision you just referenced?
After.
And to your understanding, what are the requirements of SB 824?
The SB 824 requirements are very similar to the HB 589 requirements. There are some differences. There are a few extra forms of ID that are allowed, but they're similar laws.
And so to clarify, it's your understanding that the list of qualifying IDs under SB 824 was expanded from the list of qualifying IDs under HB 589?
Yes, I believe it was.
Do you know whether there are any additional forms of ID that have been approved for voting in North Carolina subsequent to the enactment of SB 824?
I believe there was some discussion and some legislation involving public assistance IDs. I believe there's also been some deposition testimony suggesting that those may not have been actually accepted yet at this point.
Your Honors, I'd like to publish what we have marked as Plaintiff's Demonstrative Exhibit 4-4, which is a demonstrative of forms of qualifying ID in North Carolina. And Professor Quinn, does this demonstrative appear to reflect the forms of qualifying ID that we've just been discussing?
Yes, it does.
And does the left side of the slide show the forms of qualifying ID included under HB 589?
Yes, it does.
Those include DMV issued IDs
Yes,
and passports
yes,
and military IDs
yes, that's correct.
and veteran IDs
Yes,
and tribal IDs.
yes, that's also correct.
Okay. And does the middle column of the slide appear to you to list the forms of qualifying ID that were added when SB 824 was enacted?
Yes, it does.
And those include college and university IDs
Yep. Yes.
and state and local government employee IDs
Yes.
and voter IDs issued by Board of Elections, which are sometimes referred to as free IDs.
Yes, that's right.
And then a moment ago, I believe you testified you understood that public assistance IDs may have been authorized as a form of qualifying ID at some point after SB 824. Is that correct?
That's my understanding, yes.
And does seeing this demonstrative refresh your recollection that those were added under a law known as HB 1169?
Yes, that's correct.
Now, do you know whether the North Carolina General Assembly analyzed any data about the rates at which different racial groups possess these forms of ID when they were enacting SB 824?
I'll object to this. Just say I don't know that the witness has knowledge of what the General Assembly considered.
And Your Honors, I'm simply asking if he has any knowledge of that.
Objections overruled.
So I'm not aware of any information that would suggest the state legislature looked at that sort of data.
Thank you. Now, Professor Quinn, did you analyze the rates at which different racial groups possess certain forms of qualifying ID under SB 824?
I did.
And to remind the court, what conclusion did you reach on that question?
Right. So as I stated before, African-American voters in North Carolina were 39% more likely to lack qualifying ID than white voters. And that disparity was larger among recent voters. Among those who voted in 2016 and 2018, African-American voters were about twice as likely to lack qualifying ID compared to white voters.
Your Honors, I'd like to publish what we've marked as Plaintiff's Demonstrative Exhibit 4-5. About.
You lose Mr. Brockman?
Your Honor, yeah, this is Allison Riggs. I believe we may have, if you'll bear with us for just a moment.
Your Honors, I'm not sure if you can hear me. It appears our technical difficulties have resumed.
I can hear you now, but your video and I think your audio also there a minute ago was sort of coming in and out. Can you hear me?
I can, Your Honor, and I apologize for the technical difficulties. I have all of the other applications closed, and I will do what I can to remedy this as quickly as I can.
It's okay. I think you're back online now and coming through fairly clear. So if you want to try to proceed, it's fine with me.
Thank you, Your Honor. I will go ahead and do that. Professor Quinn, does this demonstrative PDX 4-5 represent the results you just described for the racial disparity between registered white and black voters in North Carolina?
Yes.
And what does it mean in concrete terms for a black voter to be 1.39 times more likely to lack a qualifying ID than a registered white voter?
So one way you can think about this is the following thought experiment. So imagine randomly selecting one black voter from the state of North Carolina and also randomly selecting one white voter from the state of North Carolina. The probability that that randomly selected black voter lacks qualifying ID is 39% higher than the probability that that randomly selected white voter lacks qualifying ID.
And I believe you testified a moment ago that those results are different if you restrict your analysis to only voters who voted in the 2016 and 2018 elections. Is that correct?
That is correct.
Your Honors, with your permission, I'd like to publish PDX 4-6, a demonstrative exhibit showing Professor Quinn's results for recent voters. And Professor Quinn, does this demonstrative accurately reflect the results you just described for recent voters?
Yes.
And in concrete terms, what does it mean for a black voter to be twice as likely as a white voter to lack qualifying ID?
So again, the thought experiment is very similar to what I just described, except now imagine randomly selecting a African-American voter who voted in 2016 and randomly selecting a white voter who voted in 2016. That randomly selected black voter is twice as likely to lack qualifying ID as the randomly selected white voter. And the same thing would be true for 2018 voters.
Now, if a voter lacks a form of qualifying ID under SB 824, what options, to your understanding, are available to that voter if they wish to vote?
Well, so one option would be to obtain some form of qualifying ID. That could mean getting a driver's license. It could mean joining the military to get a military ID. Some sorts of people will have easier times with getting various forms of ID than other folks. There's also the three exceptions in SB 824 as well: the reasonable impediment exception, the religious objection exception, and the natural disaster exception. So the voter would have to take some kind of affirmative action to one of those three exceptions or to try to get one of the qualifying forms of ID.
As to voters who choose to try to obtain ID, does your analysis support the conclusion that black voters are more likely than white voters to have to take additional steps to obtain ID?
Yes.
And does your analysis also support the conclusion that black voters are more likely to have to rely on the reasonable impediment process than white voters?
Yes.
Professor Quinn, I want to ask you a little bit now about how you reached the conclusions we've just been discussing. In your opinion, what is the best way to identify voters who lack a form of qualifying ID?
So the best way to do that is a matching analysis where one takes the registered voters in the voter file, and for each of those registered voters attempts to link them to various ID databases of qualifying ID to determine whether those voters have that form of ID or not.
And did you conduct a matching analysis in this case?
I did, yes.
At the most basic level, could you explain for the court the basic concept of a matching analysis?
I can. So at a very high level of generality, one can think of the voter file much like an Excel spreadsheet where each row corresponds to a voter record and the columns correspond to various attributes of those voters. So their first name, last 4 digits of their social security number, date of birth, etc. And one can sort of think of the DMV file in a similar way. It's a little bit more complicated than that, but essentially it's useful to think about it that way, where each row corresponds to a license record and the columns correspond to various attributes of the individuals who hold those licenses. And so the idea behind a matching analysis is to take each registered voter in the voter file and look at their measured attributes, first name, last name, social security number, last 4 of social security number, et cetera, and try to find corresponding records in the various ID files.
And I believe you mentioned in your answer identifying voters from the North Carolina voter file. Is that correct?
Yes.
And how would you describe the voter file?
So the voter file is a database that consists of records from registered voters, those who have registered to vote in North Carolina. And again, it contains information on their personal attributes, first name, last name, date of birth, et cetera. There's also some information about voting history, things of that sort.
Now, for purposes of your matching analysis in this case, did you include all of the voters in the voting file that you had access to?
No, I only included living registered voters.
Okay, and so does that mean that you removed voters who you believed were deceased?
Yes, that's correct.
And you also removed voters who you believed were no longer registered to vote in North Carolina, is that correct?
That's also correct.
Why did you do that?
So my understanding of the question here is about the effect of SB 824 on registered voters, those who could actually legitimately vote in North Carolina prior to the enactment of SB 824. And so I think it's obvious that individuals who are deceased would not be able to vote in North Carolina, regardless of the law. Similarly, those who are no longer registered to vote in North Carolina would not be allowed to vote in North Carolina, irrespective of SB 824.
Now, have you ever heard of the term deadwood in reference to a voter file?
Yes.
And are deceased voters examples of deadwood on a voter file?
Yes.
And so were the steps that you just testified about, removing deceased voters and voters who are no longer registered, an example of controlling for the presence of deadwood in the voter file?
Yes, that's right.
After taking those steps, about how many unique voter records were left?
As I recall, there were about 7.2 million.
And once you arrived at that set of about 7.2 million voters, did you compare that set to databases containing information about IDs?
I did.
Your Honors, with your permission, I'd like to publish PX72, which is a summary exhibit that we have put together in order to avoid the need to introduce highly confidential documents, and which summarizes the data files and sources of data that Professor Quinn relied on for his matching analysis. Professor Quinn, I'm showing you what has been pre-marked as Plaintiff's Exhibit 72. Does this appear to accurately summarize the sources of data and data files that you used in your matching analysis in this case?
What I can see does, would it be possible to scroll through the rest of this? Yes, it does.
Your Honors, plaintiffs would move to admit PX 72 into evidence at this time.
PX 72 is received.
Thank you. And Professor Quinn, could you please describe for the court the forms of ID that are reflected in the data captured by PX 72?
Yes, so one form are DMV issued IDs that would be coming from the DMV customer data. Another form would be information on state employees. That's actually coming from a number of state human resource files. And there's also information from colleges, universities, schools in North Carolina.
Did you request access to data on any additional forms of ID?
I did.
And did you receive data on additional forms of ID other than the ones we've just been looking at for PX 72?
I did not, no.
Why not?
It's my understanding that the request for production didn't come through, that the agency is in control of those forms of data. We're not willing to release it.
Now, with respect to the forms of ID for which you were able to perform a matching analysis, could you please explain to the court how you went about trying to identify matches?
Yes, I can. So again, at a very high level of generality, and if you'd like me to be a little bit more specific, I'm happy to do that, but I'll start with the general idea first. Again, for each registered voter in the voter file, we have information on a number of characteristics of those individuals: name information, date of birth, last four of their social security number, address information, driver's license number, etc. And so the idea in the matching analysis is to take those pieces of information and in many cases combine them to create essentially, if not a unique identifier, something very close to a unique identifier, and then try to find the corresponding values of those what I'm calling composite match fields in the various ID databases, whether that's the DMV database or the state employees data, schools data, et cetera.
Your Honors, with the court's permission, I'd like to publish PDX 4-7, which is a demonstrative exhibit illustrating the composite fields that Professor Quinn just described.
I don't know if when you do that each time there's a pause, whether you're waiting on me to respond or not. But again, I'll just tell you that you're free to publish exhibits without my permission. If there's an objection to an exhibit that you want to publish, I assume I'll hear from the defendants about it. But I'm not going to respond when you try to publish exhibits unless there's an objection, okay? So you can publish exhibits, you can show them to witnesses, you can do whatever you want to. I'm not going to respond unless there's an objection to something, okay? So I don't know if that's what you're waiting on or not, but again, you got my exhibits, okay?
I'm sorry, Judge, you broke up after, but again.
Thank you, Your Honor. Understood. That there is a bit of a lag on my system when the exhibits are posted.
Okay, I just didn't realize, and I heard you, Ms. Fawcett, and I was just saying you don't have to wait for my permission. Thank you.
Understood. And Professor Quinn, does this appear to accurately reflect the 11 composite match fields that you used in your analysis in this case?
Yes, it does.
And how does grouping these data points together allow you to identify a match?
So again, the key consideration here is to take voter characteristics in the voter file and to find combinations of characteristics that are unique or very nearly unique. In some cases, no combination of fields is necessary. So for instance, the North Carolina driver's license number, which is what I'm using for composite match field 1, that's the first row in this exhibit, is very nearly unique in the voter file. The only problem is there's a number of individuals in the voter file who do not have a North Carolina driver's license number. So that can be used by itself to link up with the DMV database. In other cases, though, there are, it would not be simply enough to just look at first name, for instance. There are obviously many Johns in the state of North Carolina. So if we look at the second row, by combining first name, and last 4 digits of the social security number, what I'm doing is taking, for each individual in the voter file, I'm taking their listed first name, their listed last name, gluing those two pieces together, and then gluing on the last 4 digits of their social security number. And then using that composite variable of 3 things, first name, last 4 digits of the social, to match against the various ID databases. And the same is true for all of these other things. So just one other example quickly, if we look at something different, composite match field number 11, the very last row, what I've done there is I've taken the last 4 digits of the individual's social security number and combined it with their birth date to create something close to a unique identifier. Again, to find individuals in the various ID files who have the corresponding last 4 digits of social and birth date.
And Professor Quinn, when you're looking for a match between the voter file using these 11 composite fields, 11 fields have to match before you conclude that a voter is a match.
I'm sorry, I think part of your question cut out with the video.
I apologize for that. I was asking how many of these 11 composite match fields have to match before you conclude that a voter is a match?
Only one.
Okay.
So
And
someone who matches on any one of these 11 is counted as a match. There's someone who presumptively does have a form of qualifying ID.
does that decision make your results and your analysis more conservative or less conservative?
I believe it makes it more conservative.
And what do you mean by more conservative?
By more conservative, I mean finding more matches.
You mentioned in one of your previous answers the uniqueness of the composite match fields. Can you explain to the court what it means for a match field to be unique?
I can try. So what I mean by uniqueness is the extent to which individual records in the voter files have values that are not shared with other records in the voter file. So for instance, if there's a composite match field that is 100% unique, that would mean that every record in the voter file has a different value of that match field.
And how unique are the 11 composite match fields that you created?
They're very close to 100% unique. Most are over 99% unique. I think the lowest uniqueness is 98.5 or so percent.
Are there other composite match fields that you could have included?
I could have, yes.
Why did you not?
The other match fields I could have used were either not very unique, which would create a problem for false positives, which I can explain if you like, or they were redundant in the sense that, so for instance, an example of a redundant match field would be if I took a driver's license number and combine that with first name, last name, and the last four digits of the social security number, right? So that would be a new, say, composite match field 12. But note that everyone who would match on that new match field, driver's license number, first name, and last four digits of social, would also match on driver's license number, match field 1, and they would also match on match field 2, first name, and last four digits of social. So for computational reasons, there's no reason to include such a match field.
Thank you. I'd like to just walk through a couple of concrete examples to make sure we understand how this matching process works. Let's publish PDX 4-8, please. And this is a demonstrative exhibit that shows illustrative examples of how the matching process works. Now, Professor Quinn, because we don't want to disclose any confidential information about actual voters during this public proceeding, we've created this demonstrative that shows information about hypothetical voters in the voter file. Does this demonstrative reflect the types of data fields for voters that you had access to in the data file or in the voter file?
Yes.
And do the first two rows on this demonstrative appear to show a matching analysis between the voter file and the DMV database?
Yes, that's right.
And does this hypothetical example show a match or a no match under your methodology?
So this would be an example of a match.
And could you please explain for the court why this first example shows a match under your methodology?
I can, absolutely. So you might wonder, right, these two records, the voter file record in the first row and the DMV record in the second row, you might note that there's a different last name for these two individuals, and you might think that might cause a problem. Right, it's certainly possible that Jane Smith or Jane Doe was recently married and changed her name, and that's why we're seeing that difference in last name. Um, Note though that these two records share a lot of other information. So they have the same North Carolina driver's license number. So that by itself would match on match string number 1. They also share the last four digits of the social security number, 5231. They share the same birth date, and they also share the same zip code and house number, right? And so those pieces of information are sufficient to generate a match, even though the last name is different across the two records.
And Professor Quinn, do the bottom two rows on this demonstrative appear to you to be showing a matching analysis between the voter file and the database from the State Human Resources Office that you had access to?
Yes.
And the data fields in that Human Resources database were slightly different. Is that correct? And from the DMV file?
Is the question whether the State Human Resources file is different from the DMV record that we're looking at, or from the voter file record that it's attempting to be matched with?
From the DMV file. For example, you did not have driver's license number in the Human Resources database?
Yes, that's correct. I did not have driver's license number in the State Human Resources file. Yeah.
And despite not having that driver's license number, you were still able to conduct a matching analysis using your methodology in this case, correct?
I was, that's right. That's correct. The zip code information is different and the house number is also different. So note that the first name is the same in the two records. The last name is the same in the two records. The soundex encoding of the last name, it's sort of a way to represent sort of the phonetic spelling of the last name, is the same across the two files. The last four digits of the individual social security number is the same, and the birth date is also the same. And so that information is sufficient to generate a match, even though the address information is different. In general, what both of these examples illustrate is that by using multiple different match fields that used overlapping pieces of information, there's some robustness built in that allows for matches to occur, even if there may be data corruption, transcription errors, or changes in things such as last name across the files.
And when you find a match in your analysis, what does that represent?
So again, a match is an individual in the voter file who can be matched to an ID record in one of the databases of qualifying ID. And so a match is a registered voter who presumptively has a form of qualifying ID under SB 824.
And what does a no match represent?
A no match is an individual in the voter file who could not be successfully matched to any ID record in the ID databases that I looked at of qualifying ID. So that's an individual who presumptively does not have qualifying ID under SB 824.
And Professor Quinn, I'd like to talk about the matches that you were able to identify. Is it possible a voter can possess more than one form of ID under 824?
I'm sorry, the audio is sort of cutting in and out again.
My apologies. With respect to the matches that you were able to identify, is it possible that a voter can possess more than one form of qualifying ID under SB 824?
Yes.
What is the most common form of ID that voters match to?
DMV issued ID.
So if a voter has a DMV issued ID like a driver's license and also has a student ID, does that count as two matches or one match in your analysis?
That would count as one match in my analysis.
Is the total number of matches between the voter file and the DMV records reported in your December report, JX5?
Yes.
Let's put up PDX 4-10. This is a demonstrative exhibit showing Professor Quinn's matching results. If we could go to PDX 4-10, please. Thank you. Professor Quinn, does this demonstrative reflect the results of your matching analysis?
Yes.
How many matches did you find between the voter file and the DMV records?
About 6.7 million.
Now, did you include canceled and suspended driver's licenses in that set of matches?
I did, yes.
Does the decision to include canceled and suspended licenses make your analysis more conservative or less conservative in terms of the overall number of matches?
I believe it makes it more conservative in the sense of creating more matches.
Now, for voters who you could not match to the DMV records, did you check to see whether you could match them to another form of ID?
I did, yes.
And how many additional or incremental matches did you identify from the board issued free IDs that were added under SB 824?
205.
And how many incremental matches did you identify from government IDs that were government employee IDs that were added under SB 824?
1,819.
And how many additional or incremental matches did you identify from school IDs that were added under SB 824?
44,422.
And so if I've done the math correctly, is that a little bit over 45,000 incremental matches provided by the new forms of ID added under SB 824?
Yes, that looks correct.
How would you describe the magnitude of these incremental matches from forms of ID added under SB 824 as compared to the number of matches to DMV issued ID?
Compared to the number of DMV matches, the additional incremental matches are minuscule.
Did you also analyze any additional or incremental matches to public assistance IDs?
I did not.
Why not?
It's my understanding that no such IDs are known to actually be available and qualifying at this point.
And now shifting gears and returning to your no match results, did you analyze the racial demographics of the no matches that you identified?
I did, yes.
And is that analysis the basis for your conclusion that Black registered voters are 39% more likely to lack qualifying ID than white registered voters?
Yes.
And is that analysis also the basis for your conclusion that African American voters in recent elections are twice as likely to lack qualifying ID as white voters in recent elections?
Yes.
Professor Quinn, in your expert opinion, does your analysis represent a reliable estimate of the number of North Carolina voters who lack a form of qualifying ID under SB 824?
Yes.
And in your expert opinion, does your analysis provide a reliable estimate of the racial demographics or composition of voters who lack a form of qualifying ID under SB 824?
Yes.
Do you know whether the state of North Carolina or the State Board of Elections conducts its own matching analyses of voters who potentially lack qualifying ID?
Yes, they have done that.
And how, if at all, does the state's matching analysis differ from the matching analysis that you conducted in this case?
So the primary difference, I would say, is the goal of the analysis. So my understanding of the state's matching analysis is that was an attempt to be over-inclusive and identify a large group of voters who should be targeted for outreach. My matching analysis was not designed to be over-inclusive. It was designed to provide an accurate measure of the number of people on the no match list, as well as the racial demographics of the no match list.
Based on that understanding, would it surprise you if
I'm sorry, I didn't, the audio went out again.
Mr. Brockman,
yes, my apologies.
let me just, it might be good if you and I'm just suggesting this to you, that I don't know what a CPU is, but I'm told that the higher your CPU usage is on a percentage basis, the more likely you are to blink in and out and audio come in and out. And so you might try this. I'm just suggesting this, is that you turn your camera off. Perhaps that will decrease the CPUs that your computer is using, and it will allow your voice to be heard loud and clear. And frankly, I'm not sure we need to always see you. So assuming you can still see and we can still hear, it might be able to help. I'm just suggesting that.
Thank you, Your Honor, and I am happy to attempt that and see if it's helpful. And Professor Quinn, based on your understanding of the purpose of the state's no match analysis, would you be surprised if voters on the state's no match list, in fact, possess a form of qualifying ID under SB 824?
I wouldn't be surprised by that.
And is that because of the over-inclusive nature of the state's list that you testified about?
Yes, that's exactly right.
Thank you. Professor Quinn, when conducting the kind of matching analysis that you conducted in this case, is it possible to run into what are called false positives?
Yes.
And is that a voter who appears to be a match but actually does not have a form of qualifying ID?
Yes, that's exactly right.
And is it also possible to run into what are called false negatives, meaning a voter who does not have an ID, a voter who appears not to have an ID when in fact they do have an ID?
Yes, that's right. So a voter on the no match list who in fact does have a form of qualifying ID would be a false negative.
What are some of the issues that could cause a false positive?
So in my experience, the biggest source of false positives is the use of composite match fields that are very non-unique, or at least not very close to 100% unique.
And does your analysis account for the issue of non-unique match strings?
It does. As I testified earlier, the match strings that I'm using, the composite match fields, um, most are over 99% unique. The lowest is, I believe, 98.5% unique.
And what are some of the issues that could cause a false negative?
So false negatives could arise if one is not careful about how one constructs the match strings. So if one only uses match strings that rely on one form of information, say last name, it would be the case that any sort of data error across the two databases that showed up in last name would prevent matches from happening, even though that individual, right, does have that form of qualifying ID. And so that's the reason that I used a number of match fields, composite match fields, 11, with non-overlapping pieces of information, and also allowing match to occur if only one of those fields matched, not requiring all 11 of those fields to match.
So for example, if a voter got married and changed his or her name, it's possible that they would incorrectly appear as a no match unless you had a match string that accounted for that possibility.
That's correct.
And am I correct that your match strings do account for that possibility?
They do. There are match strings that don't use last name information.
Would it also have been possible to engage in a manual review to check the accuracy of matches or no matches?
It would be possible, yes.
Did you undertake a manual review analysis in your reports in this case?
I did not, no.
Why not?
So it's important to think about what a manual review would do. And there are basically two different types of manual reviews, depending on the problem that one thinks may be present. So as we just discussed, one sort of problem is the presence of false positives. And there'd be one type of manual validation that one would want to perform for that potential issue. Another concern would be the possible presence of false negatives. And there'd be another sort of manual validation that one would want to do for that situation. So in the case of false positives, as I testified just a second ago, in my experience, the largest source of false positives is the use of match strings that are not close to 100% unique. And in this case, I chose match strings that were very close to 100% unique. So in my expert opinion, I don't think there's a serious problem with false positives in this analysis. The situation with false negatives is a little bit more complicated. And the issues there is that the sort of manual validation that one would want to do are extremely time intensive. So in a perfect manual validation for false negatives, what one would want to do is for each voter on the no match list. So my no match list has about 480,000 voters on it. So for each one of those individuals, one would need to go through potentially every record in the DMV file, every record in the state employee database, every record in the school and university data to see if there actually is something that appears to be a match for that person. And so, right, you can multiply out 480,000 times, I forget exactly how many DMV records there were, a little over 8 million, I believe, right? That's an enormous number of things to have to manually check. One could take a random sample of the no match list and work with that. So that would help a little bit. But one would still need to go through it and manually check whether those no matches look like some other record in all of the DMV records, all the employee records, all the school records. And that, again, is just an enormous number of things to work through. You might wonder about, would it be possible to have a large number of people work on this? Isn't this something like some sort of crowdsourcing could handle? But again, the issues there are that the underlying data are highly confidential, and so you couldn't open this up to, thousands of people to work on. And even if you did, there are subjective decisions to be made, and I would be reluctant to rely on that too heavily without being able to then subsequently validate the manual decisions that people are making themselves.
Have you ever previously conducted a kind of manual checking analysis in your work?
I have.
And can you explain for the court the circumstances in which you felt that was appropriate?
I can. So that showed up in the Curry litigation. In my main report in the Curry litigation, I do perform a manual validation checking for false positives. And the issue there was not that I thought I had a problem with my match strings. It was the case that the opposing expert put forth a matched string that very clearly was not close to 100% unique. I think it was around 85% unique, if I recall correctly. And as a result, there were a large number of false positives coming in that I suspected anyway. But to be sure that there actually were false positives coming in through that particular match string, I did engage in a manual validation of the false positives in that case. And what I found were that the match strings that I used had very few false positives. The opposing expert's match string had a large number of false positives.
Thank you. I'd like to shift gears for a moment. You mentioned earlier in your testimony that there were some forms of qualifying ID for which you did not have access to database information. Is that correct?
That is correct.
And in forming your opinions in this case, did you evaluate those forms of ID in some other way besides a matching analysis?
I did.
How did you do that?
Well, so what I did is a form of sensitivity analysis, and that shows up at the back end of my main December report. So I could go into a bit of detail, or is it sufficient just to note that I performed a sensitivity analysis?
Well, why don't we do this? Let's use an example and see if we can illustrate how your sensitivity analysis worked. passports are a form of ID that was allowed for voting under HB 589. Is that correct?
Yes, that's correct.
And in your analysis in the Curry case, were you able to include information on passport possession?
I was able to look at matches from the underlying passport or from the voter file to the passport database in that case.
Okay. And how is it that you had access sufficient to perform a matching analysis on passports in that case?
In that case, there was parallel federal litigation, and the Department of State was willing to perform a matching analysis that was specified by the federal expert in that case. I had access to the results of that matching analysis.
And with the ability to analyze that data, did you conclude that there was still a racial disparity in ID possession in the Curry case?
I did. The ratio of 2, that African American voters were twice as likely to lack qualifying ID in the Curry case, that was after accounting for passport possession.
You testified earlier that passports are also an X24. Is that correct?
You broke up there, Mr. Brockman. Could you please repeat that?
Sure. My apologies. You testified earlier that passports are also an acceptable form of ID under SB 824. Is that correct?
Yes,
But you did not have access to data on passport possession sufficient to conduct a matching analysis in this case, correct?
no, I did not.
You did conclude, based on the matching analysis you were able to conduct, that African American voters were 39% more likely to lack qualifying ID than white voters. Is that right?
That's correct.
And assuming that's correct, what would need to be true about the rates at which African American voters possess passports relative to white voters in order for that 9% disparity to be reduced?
So the new matches coming in from passports, it would have to be the case that African American voters would be more than 39% more likely to be getting those new matches from passports than white voters.
And were you able to analyze in this case any data on the extent to which African American and white voters are likely to possess a valid passport?
I did look at some forms of information, some data, yes.
Which data did you look at?
I looked at data from North Carolina from the American National Election Study, which is a large sample survey conducted in the US.
And what did those data tell you about the rates at which white voters possessed passports compared to black voters?
What I found from those data was that white voters in North Carolina are about 2.4 times more likely to possess unexpired passports than black voters.
And based on that information, in your expert opinion, is it plausible that passport possession would eliminate the racial disparity in ID possession that you observed through your matching analysis in this case?
I don't think it's plausible that passports would eliminate the racial disparity that I found in the matching analysis.
And why not?
Well, so as I testified a second ago, it would have to be the case that black voters are disproportionately more likely to possess passports than whites for this disparity to go away. And what we're seeing from the American National Election Study data is that, in fact, whites are much more likely than blacks to possess unexpired passports.
If anything, what does the data about passport possession suggest would happen to the racial disparity if you were able to perform a matching analysis on passports?
So if anything, my best guess is that including passports into the matching process, if I were given access to the underlying passport database, my best guess is that the racial disparity would actually increase. It would be something bigger than 1.39.
Now, Professor Quinn, is the plausibility analysis that we just discussed an example of the kind of sensitivity analysis that you conduct in your report?
Yes.
And did you conduct similar analyses for the other forms of qualifying ID under SB 824 for which you did not have data that permitted a matching analysis?
Yes. So the way the sensitivity analysis is set up is that every form of ID that was not explicitly matched against in my matching analysis, but is a form of qualifying ID, those are all rolled up together in the sensitivity analysis. Those are what I call other IDs in the sensitivity analysis.
And after conducting your sensitivity analysis, did you form an expert opinion as to whether it is plausible that those other forms of ID could erase the racial disparity that you observed through your matching analysis?
In my expert opinion, it's not plausible to think those forms of other ID would erase the racial disparity that I uncovered in the matching analysis.
Professor Quinn, to summarize, does your analysis in this case show a disparity in the rates at which Black voters in North Carolina and white voters in North Carolina possess forms of ID acceptable for voting under SB 824?
Yes.
What's the magnitude of the disparity?
So overall, Black voters are 39% more likely to lack qualifying ID than white voters. If we restrict our attention to recent voters, those who voted in 2016 or 2018, that disparity is larger. Among those sets of people, Black voters are twice as likely to lack qualifying ID than white voters.
And that means that Black voters are at 39% more likely than white voters to have to go out and obtain an ID if they want to vote. Is that correct?
That's correct.
And amongst recent voters, Black voters would be twice as likely to have to go out and go through the steps necessary to obtain an ID than white voters.
Yes.
And so as a result of those disparities, is it true that Black voters are more likely than white voters to need to take additional steps to obtain ID acceptable for voting under SB 824?
Yes.
Thank you, Professor Quinn. I have no further questions for you at this time, and I will tender the witness.
All right, Mr. Patterson, you may cross-examine the witness.
Okay, thank you, Your Honor. This is Pete Patterson for the Legislative Defendants. Dr. Quinn, nice to see you again.
Likewise.
Yes, I would like to start by pulling up your report, which is JX005. And I'd like to first look at paragraph 11.
Oh, I have my hard copy. I'll pull it up. I wasn't sure if this is coming up on the screen or not.
It will come up on the screen, but
Okay.
if you would like to follow along in hard copy, that would be fine. Okay, then we wanted to go to paragraph 11. We could zoom in on that a little bit, that would be great. Maybe one more time. Okay. All right, great. So this says that Senate Bill 824, SB 824, enacted in December 2018, requires that all individuals who vote in person present certain forms of identification that contain a photograph of the registered voter, correct?
That's what it states, yes.
But voters can vote without an ID by filling out a reasonable impediment form, correct?
That is one of the exceptions.
So it is not true that SB 824 requires that all individuals who vote in person present certain forms of identification that contain a photograph, correct?
I don't have the full text of the statute in front of me. I just have my summary of it later on in my report. And so I would want to actually look at the text of the statute to before answering that yes or no.
Okay, so you do not know whether voters are required to present an ID to vote or not. Is that your testimony?
So my understanding is that SB 824 starts with the assumption that all individuals who vote in person will prevent the enumerated set of IDs. But as I've also testified, there are the three exceptions: the reasonable impediment exception, the natural disaster exception, and the religious objection exception. And so, right, to the extent that those are deviations away from that, those would be situations where the individual may not have to present the photo ID at the time of voting.
Now, you did not consider the impact of the reasonable impediment or other exceptions in your analysis, correct?
I was not asked to opine on those questions.
So you did not consider them, correct?
I did not look at them explicitly in this analysis.
Did you look at them implicitly?
My analysis was entirely about the rates of ID possession and the extent to which there was or was not a racial disparity in ID possession.
Now, you served as a testifying expert for the defendant interveners in South Carolina versus United States, correct?
Yes.
And that case involved a challenge to South Carolina's voter ID law, correct?
Yes.
And you conducted a matching analysis in that case, but it was not submitted to the court, correct?
I believe I've testified to that previously, yes.
Instead, excuse me, did someone speak? I'm sorry. Okay. You testified in that case that it was unlikely that South Carolina's reasonable impediment exception would rectify any pre-existing racial disparity in photo ID ownership, correct?
So I was asked to opine on the reasonable impediment exception in that litigation. And I don't recall if the words you just quoted were exactly from my report in that case or not, but I did reach the conclusion that the South Carolina reasonable impediment exception was unlikely to eliminate racial disparities.
Okay. I'd like to bring up JX 0841, which is the three-judge district court decision in that case. And I'd like to turn to page 40 of that opinion. Looks like we're there. If we could blow up that paragraph that starts with "but even." Okay, so the court there found that, but even though the South Carolina law, absent the reasonable impediment provision, may have run into problems under Section 5, the sweeping reasonable impediment provision in Act R54 eliminates any disproportionate effect or material burden that South Carolina's voter ID law otherwise might have caused. Based on this passage, is it fair to say that the court rejected your submission in that case?
I can read what the text says. I think everyone in the courtroom can reach their own conclusions about what that means.
In your view, is that consistent with what you submitted to the court in that case?
I'm sorry, which part of that is consistent?
Is the part that says that the sweeping reasonable impediment provision in Act R54 eliminates any disproportionate effect or material burden that South Carolina's voter ID law otherwise might have caused, consistent with what you submitted to the court in that case?
So as I recall, what happened in that case was that during the trial, the I forget who the person was, but one of the officials from the state, I believe the State Board of Elections, testified that the implementation of the reasonable impediment exception would be different than what it appeared to be prior to the trial. And to the extent that that changed partway through, I think that's at least partly related to why there's this discrepancy.
Okay, so given that change that was made partway through trial, as you describe, do you agree with the court's holding, taking that change into account?
Objection, Your Honor. May I be heard?
Yes, briefly.
Professor Quinn is not being offered as an expert on the South Carolina voter ID law in this case, nor do I think it's appropriate to ask him for a legal conclusion based on a hypothetical analysis that he did not conduct in the South Carolina case.
The objection is sustained.
Okay, you do not recall the details of the South Carolina statute, correct?
It's been quite a while since I've looked at it.
You therefore cannot say whether there is anything on the face of SB 824 that would lead you to believe the reasonable impediment provision would have a different operation in North Carolina than South Carolina's reasonable impediment provision, correct?
So as I've previously testified, I have not studied the reasonable impediment exception under SB 824, and it's simply something I don't have any knowledge of in terms of how it would be implemented.
Now, your report in this case reflects the results of a matching analysis you conducted between the North Carolina voter file and various databases containing records of certain qualifying ID, correct?
We're talking about the current case today.
The current case, yes, we can take
Okay.
South Carolina down.
Okay. I'm sorry, could you repeat the question?
Yeah, your report in this case reflects the results of a matching analysis you conducted between the North Carolina voter file and various databases containing records of certain qualifying ID, correct?
Yes.
Now, in your direct testimony, I believe, I just want to make sure I have this testimony correct, you said that you believe your analysis is a reliable analysis of the number of individuals who lack qualifying ID in North Carolina. Is that correct?
I believe that's correct, yes.
Now, we're using reliable in the terms of if you performed the same analysis, it would consistently lead to that result, which is, I believe, the technical use of reliability in statistics.
Yes. That is so when we're thinking of a measurement problem, that would be the standard definition of reliability.
Now, is it your opinion that your analysis provides a valid conclusion about the number of individuals who lack qualifying ID under SB 824?
To the extent my conclusions are that I believe there is, in fact, a racial disparity in ID possession, and that African-American voters are more likely to lack qualifying ID than white voters, I think my conclusions are valid.
Right, but my question was, do you believe your conclusions provide a valid conclusion of the number of voters in North Carolina who lack qualifying ID under SB 824?
Could you be more specific about which numbers you're referring to?
Yes, so I guess I could phrase it this way. Do you believe that the number of voters on your no match list is a valid measurement of the number of voters in North Carolina who lack qualifying ID under SB 824?
So, as I've testified, I did not have access to some forms of ID that are qualifying. So passports, military IDs, veterans IDs. And if the analysis from Curry is any indication, there are likely additional matches out there to those forms of qualifying ID, mainly passports, but also military IDs and veterans IDs. And what that implies is that the ultimate number of individuals on the no match list after matching to the passport data, the military ID data, and the veterans data would be smaller. There would be some of those individuals on the no match list currently would be likely matched to the passport data in particular, but also military IDs and veterans IDs.
Let me stop you right there. It's 11 o'clock, time for our morning break. We're going to take about a 15-minute recess at this point. We'll come back at 11:15.
Thank you.